So welcome to the very first of 3 student debate preparation webinars, Intellectual Property in Focus. What is it? Who is it for? And I'm Stephanie Couch, the Executive Director of the Lemelson MIT program. And we are really especially excited about this debate topic because we have a growing number of K-12 creators and inventors across the United States who need an intellectual property system that helps protect their good ideas. We love the spotlight on this important topic and are counting on these excellent high school debaters to help more people understand the nuances of the intellectual property system. The National High School debate topic this year is resolved: the United States federal government should significantly strengthen its protection of domestic intellectual property rights in copyrights, patents, and/or trademarks. Tonight's webinar, IP 101, is an orientation to intellectual property. On October 24th, we will focus on hot topics regarding United States intellectual property laws and careers in intellectual property. And then in our last webinar, November 20th, the topic will be a deep dive into arguments for and against strengthening the U.S. intellectual property protection laws. So that last session will include individualized coaching for our high school debate teams and questions and answers that they might need to strengthen their work for everybody who pre-registers. So if you know of a team that needs this, please make sure that they pre-register with us. And we will put the link to the registration form in the chat right now. So now I'd like to introduce Gail Su, Senior Counsel at Google, who will be monitoring our Q&A. Please put all of your questions in the Q&A so that we can get to them this evening. And I'd also like to introduce you to Shirley Fung, a patent agent with Acona, who will be introducing our speakers. Before I turn it over to Shirley, I'd like to thank our sponsors and the planning team and the advisors who have all made today's webinar possible. I believe we have a slide showing everyone who has done that great work with us. And, you know, this is a really tough topic. We couldn't have done this webinar without them. There we go. So thank you very much for everybody who's made tonight possible. Again, at the end of the session, we'll be taking questions. And with that, I want to hand it over to you, Shirley.
Thank you, Stephanie. Today, we're going to explore different aspects of IP law and policy with 3 expert speakers. First, we have Marcia, IP attorney from TradeSpace, on the topic of what is actually intellectual property. Then we'll be speaking with Dina, Vice President and Associate Chief IP Counsel at 3M, covering the topic of copyrights. Marcia will return to the podium then to discuss Trademarks 101. And then we'll have Cannon finish us with from the Associate of Morgan Lewis to present Patents 101. These speakers bring diverse expertise from the IP field, and we encourage you to take notes and submit questions during the presentation so that we can have some questions and answers happening towards the end. Let's begin with Marcia from TradeSpace. Give me 1 second.
Welcome,
here.
everyone.
I'm just going to share my screen. Sorry. Let me see if I can take over and share my screen. How does that look?
Great.
Awesome.
So you can just go straight to the next slide. Perfect. Welcome, everyone. I'm here to begin today's conversation about intellectual property. This is a topic that I'm very passionate about, and that I hope that at the end of this, you'll be as well. Or at least you'll be very excited to explore this topic in your debate journey this year. In this short introduction, I'll provide you with a basic framework for understanding intellectual property. The other sections of the presentation will address different forms of IP in more detail. So what is intellectual property, and what do we mean when we talk about intellectual property rights? It's useful to start by taking a look at what each one of these words mean, the word intellectual and the word property. Next slide. The first word in our exciting topic today is intellectual. What does that mean? You can look up the dictionary definition, and you will see that this means we are talking about concepts that relate to the intellect. More generally, the word intellectual in this context refers to something that is created by the mind, rather than something that is physical or tangible. Now, we all understand tangible and physical things that we can touch, like cars, homes, cell phones, etc. Intellectual property deals with things that we can touch, creations of the mind, like inventions, stories, brand names, photographs, songs, and so on. The word intellectual in the context of intellectual property therefore implies that the property is the product of intellectual or creative effort. Next slide. How about property in this context? Now, intellectual property is a legally created system that, again, allows people to own their intangible creations, their creations of the mind. What does property and ownership mean here? Now, this is a very complex issue, but to simplify it, let's talk about owning a home. If you own your home, that home is your property. You have the right to keep others off your property. You have the right to sell your property. You have the right to share your property with others and charge them rent. Intellectual property is no different. Even though this varies by the specific forms of IP that we'll be discussing later, intellectual property in general is concerned with giving creators legally recognizable rights to their creations. So, while the term intellectual property refers to the creations themselves, the term intellectual property rights refer to the legal protections that are awarded to the owner or owners of those creations. Next slide. So I've hinted at this, but intellectual property is actually an umbrella term that covers a category of legally recognizable rights. There are four main types of intellectual property: patents, trademarks, copyrights, and trade secrets. Patents apply to inventions, which can be viewed broadly as technical solutions to technical problems, or anything new and useful under the sun made by a human. Things like machines, processes, devices, and so on. For example, you can have patents for a new robot that can bring us a snack on demand. Trademarks, on the other hand, apply to words, designs, logos, colors, or sounds that identify a product or service. This could be, for example, a new logo that you design for your future startup company. Copyrights deal with works of authorship, such as books, song lyrics, musical compositions, and photographs. This will be, for example, your future copyrightable novel that you publish and that we can't wait to read. And lastly, we have trade secrets, a category of intellectual property that we won't be discussing in detail today, but that is very, very important. Trade secrets protect information that is carefully kept secret, like your family's chocolate chip recipe that everyone will love to have, but that you keep it as a secret to give you that special edge, that special advantage when you bring your cookies to a party and everyone delights in how good they are. Now, this was a very, very short introduction. but please be patient because patents, trademarks, and copyrights will be discussed later in more detail. So you can have more detail on each one of these topics. Next slide. So before we move on to the different categories of IP, I want to end this introduction with a few words on why you should care and why you should be very excited about this topic for your debate league. First, it's important to recognize that intellectual property rights are so strongly embedded in the fabric of our country that they were enshrined in our Constitution by our founding fathers. The language of the Constitution really tells you why IP is protected by law and why it matters. Article 1, Section 1, and Clause 8 of the US Constitution states that Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Our founding fathers were true visionaries when they guaranteed intellectual property rights in our Constitution. They recognized that giving creators ownership of their creations is truly essential to encourage people to create, and also essential in encouraging companies to invest in the creation of new technologies and new solutions to problems. Think about the ingenuity of our pharmaceutical industry, for example, and the investment that is required to create a new drug or a vaccine. It can cost over $100 million on average to create a new drug. If the company that invested $100 million to create the drug was not allowed to own that drug and keep other companies from making that drug, they would never have the economic incentive to invest in creating new drugs. And that's why, one of the reasons why IP is so exciting. IP encourages innovation and is a boost for economic growth. IP is also a way for companies to get credibility in the market and increase their valuation. Now, some of you may have seen the show Shark Tank, and the investors there often asking about the IP protection for a new product or service. And after this talk, you will know why IP rights are so important to an investor and our economy in general. So now I will turn over to Dana to discuss copyrights.
Thank you, Marcia. Good evening, good afternoon, everyone. I'm delighted to be here to talk about U.S. copyright basics. So first and foremost, we're going to start with the question of what is a copyright. As Marcia pointed out, the legal basis for copyright is found in our Constitution. Article 1, Section 8, Clause 8 of the U.S. Constitution is also often referred to as the Copyright Clause. This clause states that U.S. copyright law protects original works of authorship fixed in any tangible medium of expression now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. You can find out more about U.S. copyright law in the Revised Copyright Act of 1976 and Title 17 of the U.S. Code. As we dive in a little bit deeper to unpack this language, it's important for us to think about a couple of the terms that I just read for you. So in the phrase, this word original, meaning original works of authorship, when we use the word original here, we mean not copied or having a minimal amount of creativity. The phrase also says original works of authorship fixed in any tangible medium of expression. So the phrase fixed in any tangible medium of expression means the work exists in a tangible form. So these are things like books, paintings, photographs, hard drives, videos, even something that you jot down on an envelope. The minute that you write it down, it's fixed in a tangible medium. A speech or presentation that's given orally, however, and not written or recorded is not considered fixed in a tangible medium. Copyright is an intangible intellectual property right that is distinct from the material object in which the copyright work is embedded. So ownership of a book or a CD or a DVD or an original work of art, for example, does not give you ownership of the copyright that underlies that work. Publication is not required for copyright protection, so unpublished works are also protected if they're original and fixed in a tangible medium of expression. Okay, so then when is a work protected by copyright? A work is protected by the copyright as soon as it's created and fixed in a tangible medium of expression. No copyright notice is required. No registration is required. Authors may register their works with the U.S. Copyright Office, which is a service unit of the Library of Congress, if you're wondering. Registration is required as a precondition to initiating a copyright infringement claim or lawsuit. And timely registration can provide benefits such as entitling a copyright owner to statutory fees in the event that their copyright is infringed. However, registration is not a prerequisite to have copyright protection. What kinds of works are protected by copyright? Copyright protects a wide variety of works. Among them are things like literary works. So those are books, newspapers, computer software, scientific journals, websites, letters, memos, product brochures, maybe like all those college brochures that you're getting if you're a junior or senior in high school, product packaging, those sorts of things are literary works. Copyright protects musical works, including lyrics. It protects dramatic works, including plays, musicals, operas for the stage, movies, or television. It protects pantomimes and choreographic works, including dance. It protects pictorial, graphic, and sculptural works, including 2- and 3-dimensional works of fine art, graphics, applied arts, photos, prints, reproductions, maps, globes, charts, models, technical drawings, even like architectural drawings. So, if any of your parents have decided to build a home and you've received those architectural drawings as part of the phase of building, those are protected as pictorial or graphic works in copyright. Copyright law also protects motion pictures and other audiovisual works, including movies, video games, slideshows, and telecasts. It protects sound recordings, things like words and music. And then computer code and its original language and the resulting object code, even if it's readable only by a machine. Okay, so that's a lot that's protected by copyright. What's not protected by copyright? Copyright does not subsist in ideas, methods, systems, discoveries, blank form, in names, titles, short phrases, facts, useful articles. Those may be protected by other forms of IP we'll learn about later. And listings of ingredients such as recipes, formulas, and compounds. However, while these items are not protected by copyright while standing alone, they may be combined with copyrightable subject matter so that you're not free to always use them. For example, while a standard blank calendar is not protected on its own, art or text included in the calendar may be protected under copyright law. Similarly, a simple listing of ingredients in a recipe is not protected, but photos or texts explaining how to prepare the recipe may be protected. Further, there may be protection available for these items under, like I mentioned before, other forms of IP like patents, trademarks, trade secrets, or other IP law. How long are works protected by copyrights? Copyright protection lasts for a really long time. Works that are created on or after January 1st of 1978 are automatically protected by copyright upon creation and they're protected for terms determined as follows. So generally, copyright will endure for the lifetime of the author plus 70 years. In the case of joint authors, copyright will endure for the lifetime of the last surviving author plus 70 years. In the case of works made for hire, these generally include works created by employees in the course of employment and certain works created by independent contractors under written agreements, anonymous works and works created under synonym. Copyright will endure for 95 years from the date of the work's first publication or 120 years from its creation, whichever expires first. Works created before January 1st, 1978 fall under different rules than this, and determination of whether or not a pre-1978 work is protected by copyright needs to be made on a case-by-case basis. I thought I saw a question pop up. What would be the economic impact if term of copyright protection is reduced? And maybe that's something that we can take up in a minute after I work through my last few questions here. Okay, so who owns the copyright in a work? Under copyright law, the copyright is owned by the author of the work. So if there are multiple authors, the copyright can be jointly owned. As used in copyright law, the author includes individuals such as novelists, biographers, artists, lyricists. However, the copyright law also defines author to include employees, like we were just talking about, or people for whom a work made for hire is prepared. So work made for hire arises only in two circumstances. The first circumstance is a work that's prepared by an employee within the scope of his or her employment, or the second instance is a work that is specially ordered or commissioned for one of the 9 uses that we just talked about above in copyright law. For these types of work made for hire, the parties need to have an expressly agreed upon agreement that's signed in writing that the work would be considered to be a work made for hire. What protection then does an author have? A copyright owner has a bundle of exclusive rights in the copyrighted work. Generally, these rights can be divided and transferred or licensed separately to any number of third parties. And these rights include the right to reproduce the copyrighted work. So that's the right to make copies of the entire work or portions of the work. This includes the right to authorize others to also make copies. It also includes the right to prepare derivative works. And derivative works are new works that are based on the earlier underlying works. So an example of a derivative work would be a new version of Microsoft Word, a new edition of The Joy of Cooking, or a movie based on a book, for example. The rights in copyright also include the right to distribute copies of the copyrighted work to the public by sale, rent, license, or other transfers. It includes the right to publicly perform copyrighted works, the right to publicly display copyrighted works, the right to publicly perform sound recordings by means of digital audio transmission. And it also includes moral rights, including rights of attribution and integrity. Under US copyright law, moral rights only apply to works of visual arts. So those are defined to include certain original and limited edition works of arts. Copyright owners may also sue for copyright infringement if one of their exclusive rights are being used without their permission. And a common defense for copyright infringement is called fair use. Fair use allows an unrelated third party to use a copyrighted work without permission from the author or copyright owner for various purposes. For example, criticism, commentary, news reporting, teaching, or research. Those are some examples of exemplary fair uses and are not necessarily always deemed fair use by the courts. Copyright law provides 4 factors to be considered when determining for the courts whether a use falls in the fair use bucket. These 4 factors include the purpose and character of the work, including commercial versus nonprofit educational use, the nature of the copyrighted work, the amount or portion of the work used when compared to the entire copyrighted work, and the effect of the use upon the value of the work or the potential market for the work. And while no one factor is determinative, the most historically influential factors are the first and fourth. So those are the purpose and character of the work and the nature of the copyrighted work. I'm sorry, the purpose and character of the use, not the work. The purpose and character of the use and the nature of the copyrighted work. Those are historically the most determinative factors. All that being said, because fair use is a fact-dependent and case-specific analysis, there's not really a bright line rule to determining fair use. Last and certainly not least, in theory, why does this right exist? So as previously discussed, copyright protection in the US originates from our Constitution. Our constitutional framers believe that protection of exclusive rights of authors and their works for a limited time would promote the progress of science and useful arts. The public policy behind copyright is to encourage and reward authors to create new works and to make those works available to the public to enjoy. At the same time, authors of new works are rewarded. The theory is through granting certain exclusive property rights to authors, the public also receive benefits from the author's works, which may not otherwise have been created, published, or otherwise disseminated, but for the benefit to the author. That said, copyright law does not require authors to disseminate their copyrighted works for them to be protectable under copyright laws. That's the end of my substantive presentation. I am not sure, are we taking questions now or are we holding them till the end? Shirley or Gail, what do you advise?
We're
So
holding them to the end. Oh, sorry.
Okay. All right, so I will pass it back then to, who's up next?
So actually, sorry to interrupt. There is actually a question on copyrights. Maybe we can just go through it real quick before we turn over to patents. So the question is there a limit to the number of people who file for a copyright?
Is there a limit to the number of people? No, there can be multiple joint authors or creators, if I understand that question right.
Feel free, if that didn't answer your question, Alex, feel free to follow up in the Q&A. All right, sorry, we can move on to patents.
Okay, thanks.
Thanks, Dina.
Yes, we are actually going to go back to discussing trademarks first before we move on to patents. So as I mentioned before in our introduction, trademarks apply to names, logos, slogans, and other things that can represent a business. Now, I love this category of IP, and I think you will too, because it is so visible. It's literally everywhere in our world. You walk down the street and you are inundated with images of brands, slogans, and logos that you can immediately associate with companies. So why trademarks? Fundamentally, a trademark gives its owner the ability to stop others from using your brand identity in a way that might confuse consumers or damage your brand's reputation. A trademark also helps protect against the sale of counterfeit products and prevent others from falsely claiming that their products are yours. Next slide. Trademarks indicate the source of goods and services. What does that mean? Imagine you're a fan of a particular brand of coffee to keep you energized during your debate prep. You're walking down the street and you are thirsty. You see a logo associated with that brand and you immediately recognize that store. Now, you like it, you want their coffee, and you decide to go in and get one. Now, imagine you're walking down the same street and you see the logos for both your favorite brand and its close competitor. Both are great brands and both produce great coffee, but you have a strong preference. You see the signs and you have an expectation of how their coffee will taste. That's where trademarks come into play. Trademarks help companies differentiate themselves, meaning trademarks help them stand for something that customers value. When you see the logos of your favorite coffee brand, you're likely to have an immediate reaction. One brand means something to you. Another brand means something else. They are both associated with different companies with different products. You prefer one, and the logo helps you recognize that one of those two companies will give you the experience you want. Take another example, the gaming controllers shown on the screen. At a quick glance, both look very similar. If you're walking down the aisles of an electronics store, you might recognize both as basically the same thing. But when you look more closely, you see that one has a recognizable logo in it. And that logo may be the same logo that it's in your game console. You know your game console, you like your game console, it gives you a certain experience that you enjoy. The logo on that console comes to represent the joy that you're experiencing from gaming. So when you walk down the aisle and you see these two products, you might automatically assume that the controller with that logo will give you that experience and you're going to choose the product over the other one. Next slide. Now, you can think about the purpose and intention of trademarks when you go out there in the real world and you try to create a new fashion brand, for example. One of the most important decisions you will make as a founder will be to establish your brand identity and protect its trademarks. Your brand will give you that association with your company and will also position your company in the market. Now, will your hoodies and sweatpants be recognized as luxury items or discount ones? How do you want consumers to perceive your brand and recognize it in the market? What values and principles do you want your brand to represent? One aspect you need to consider is whether your brand will be distinctive. You should, in general, avoid generic terms, like, let's say, calling your brand Sweats. It's much harder to get legal protection for a common generic term that cannot be claimed exclusively by one party to the detriment of others. You should also avoid writing off the success of other brands in selecting your own. Other brands of sweats may already have significant brand awareness, and you want your own brand to indicate to consumers that are buying the sweats from you and not from them. So your brand should be distinctive enough that it won't create confusion with other brands in the market. Next slide. So one of the rights that a trademark owner has is the right to prevent other companies from using a brand that might be confusing. Let's look at those shoes, for example. The images of the shoes make an important point. Something that indicates the source of the shoes need not only be a name or a logo, it can also be the design of a product. There are some products out there that have such a widely recognized and distinctive design that they practically function as trademarks. Now, one of these shoes, you may know, was designed by a very famous celebrity, and they cost a lot of money. The other shoe is a knockoff copy, sold by a discount retailer. To the naked eye, these shoes look very similar. The celebrity designer actually filed a lawsuit in this case against the discount retailer alleging trademark infringement. At the center of the lawsuit was the issue of confusion between the two shoes and the brands and the dilution of the supposedly luxury version by the celebrity designer. The lawsuit was ultimately settled, but this provides a good example of some of the things to avoid when you are selecting a new brand and selling your products in the market. You should establish your unique brand identity and protect it with trademarks to avoid copycats. Next slide. Now, we've hinted at this, but just to emphasize it further, a trademark gives the owner the right to stop others from using a name, slogan, logo, song, etc., that would confuse ordinary consumers. Let's return to our coffee example. Your favorite coffee store has invested very heavily in creating a brand that consumers can instantly recognize and appreciate. Now, imagine a knockoff brand that may throw you off in thinking their store is actually from your favorite brand. You might shop there, mistakenly believing that it is your favorite coffee shop. If you are not confused, you will not think twice and avoid it altogether. Trademark rights protect against this. Remember that we discussed earlier in our introduction that IP rights exist to incentivize investment. Well, trademark rights exist to incentivize companies to invest into their brand and brand identity, knowing that they can prevent others from trying to get the benefit of that brand recognition. Now moving on to our last trademark slide. So you already heard in the copyright section that not everything qualifies for copyright protection. Same is true for trademarks. The big thing to understand here is that according to the law, the trademark's name should not be similar to goods and services that you sell under the trademark. Like our sweats example. The law allows us to own names that have nothing to do with the things we're selling, like completely made up unique brands. For example, using the name of a rainforest to designate a store that sells many different kinds of products. Or consider very famous coffee brand, Starbucks. Now, Starbucks sells coffee. What is a Starbucks? Is it a coffee? No, it's a name that has nothing to do with coffee. Starbucks is not a type of coffee, it's not a noun for coffee. Now, contrast it with a name like Tasty Coffee. You might open a coffee shop and call it the Tasty Coffee Shop. But what is Tasty Coffee? The name simply describes the products sold in that store. So it can actually be a very rewarding part of the creative process to come up with a distinct brand that doesn't relate to the products or services being offered, and later impart the brand with meaning and secure protection for the brand with trademarks. If we rewind time 50 years, the name Starbucks did not mean anything back then, other than maybe a fictional character. But over time, the company used the name and made it stand for coffee in a specific coffee experience. So as you can see, trademarks are a lot of fun, and it's a very creative area of practice of law. And we're now going to move on to Kannan to discuss patents, which is another super exciting area of IP. So thank you for listening.
Thank you, Marcia. So, I mean, trademarks and copyrights are always fun to discuss. Trademarks, especially, you'll have drawings, and in a way, patents have drawings too. So what are patents? Patents tend to cover ideas as much as copyrights cover expressions. So I want to start with asking a question. Did you know that every time you use a Snapchat filter or play Fortnite, you're interacting with something protected by patents? From group selfies to virtual reality, patents shape the world around us. What's a patent? A patent is a government-granted right that gives an inventor the right to exclude others from making, using, selling, and importing their invention for a limited time. So this is an exclusionary right. This does not give the patentee, the person who's granted the patent, to make, use, or sell or import their invention, but it grants them the exclusionary right to exclude others from doing so. So some of the requirements for a patent include a novelty, which requires that the invention must be new and not known to the public. It must be non-obvious, which means the invention must be a significant improvement over what already exists, not just a minor change. The patent or the invention must have some practical application. This is a very low threshold, and almost anything will have some practical use. So in this context, prior art is a common term that's being used, and any publicly available information, for example, can predate a patent application, and that may be considered a prior art. Patent office examiners can use this to determine if an invention is truly novel. Apart from this, there are other requirements for getting a patent, one of which is an enablement requirement, which requires that the patent application, when written, must describe the invention in sufficient detail that a person skilled in the relevant field could make and use the invention without performing undue experimentation. And each of this is a legal term. What undue experimentation means is very technology specific or very application specific. So when is an invention protected by a patent? An invention is only protected by a patent if it's been approved by the US Patent and Trademark Office. Unlike copyrights, protection does not start automatically when an idea is created. The inventor has to apply and go through a detailed process, which is usually a back and forth with the patent office. You can think of it as a negotiation. So some of the other details in this context can be like, what is a provisional patent application? Inventors can file a provisional application to establish an early filing date. This gives them 12 months to file a non-provisional application. So once an application is filed, inventors can use the term patent pending to warn potential infringers, although this does not provide any legal protection yet. So what type of inventions are protectable or protected? Patents cover a wide range of inventions. There are three main types. One is utility patents for new processes, machines, or compositions. Example, new drug formulas, computer hardware. You can file for utility patents. The second one is the design patents for original and ornamental designs. An example is the shape of a Coca-Cola bottle or the design of an iPhone. Some of you may know the $1 billion that was that was involved in the the iPhone wars, the smartphone wars included design patents. Plant patents for new varieties of plants that are asexually reproduced. So in this context, you may hear terms like business method patents, a type of utility patent that protects new methods of doing business, often related to software or financial services. So what cannot be protected? So laws of nature, natural phenomena, abstract ideas or mathematical formula, literary, musical, and artistic works, these are protected by copyright. Inventions offensive to public morality. So in the context of abstract ideas and specifically with regards to software, it has become all the more difficult to secure patents in the space because of a Supreme Court case a decade ago. The court case is, you can Google this, it's called Alice Corp versus CLS Bank International. This court case set a precedent for determining when software and business methods are too abstract to be patented. So while naturally occurring substances cannot be patented in their natural form, modified versions or extraction methods may be patentable. So how long does a patent protection last? Utility and plant patents last about 20 years from the date of filing. Design patents, 15 years from the date of approval. After that, the invention enters the public domain and anyone can use it without permission. So there is a concept called patent term adjustment. If the USPTO delays processing an application, the patent term may be extended to compensate for that delay. For certain products, example, pharmaceuticals that require regulatory approval before marketing, the patent term may be extended to account for the approval process time. So who owns the patents? Usually the inventor owns the patents, but if the invention was created at work, the employer may own it. This is often spelled out in employment contracts. If two or more people work together, they may share ownership of a patent. And this is called a joint ownership, right? When multiple inventors contribute to a patent, they're considered joint inventors and have equal rights to the entire patent, regardless of their level of contribution. So what rights do patent holders have? A patent holder has the right to stop others from making using, selling, or importing their invention. They can license a patent for royalties. They can sell the patent rights. They can sue for patent infringement. A couple of terms, that legal terms, maybe one of which is doctrine of equivalence. This is a legal rule which allows a patent holder to claim infringement, even if the alleged infringing product does not exactly match the patent claims, as long as it performs substantially the same function in substantially the same way to achieve a substantially similar result. Exhaustion doctrine. Once a patented item is sold, the patent holder's rights are exhausted for that particular item, allowing the buyer to use or resell the product without further permission. So why do we have patent rights? Patents exist to promote innovation by giving inventors temporary exclusive rights. This encourages inventors to share their ideas, knowing that they will be protected. Once a patent expires, others can build on those ideas. So one thing to remember this, the US switched from a first to invent to a first to file system back in 2013, aligning with most other countries. This means the first person to file a patent application has priority, regardless of who invented first. There is also this concept of grace period. In the US, inventors have a 1-year grace period after public disclosure of their invention to file a patent application. However, this grace period does not exist in many other countries, potentially affecting international patent rights. And patents are, of course, country specific. And there is a way to file what's called a patent cooperation treaty, PCT application. But then those applications have to be nationalized or filed individually in specific countries to secure rights in those specific countries. So I want to leave you with that. Patents are not just about protecting inventions. They're about shaping the future of innovation. Whether you're flying, you're using skateboards, whether there are life-saving treatments or the next viral game, patents make it possible for inventors to profit from their creativity. With AI on the rise, the debate around patents is only getting more interesting. So think about how protecting creativity today shapes the world we will live in tomorrow. Thank you.
Thank you, Kannan.
Okay, thank you. So now we will turn to Q&A. There were a few questions that were answered in the chat, and Dina, if you don't mind, if we could go through those orally as well too, so everybody has the benefit of your answer. So the first question was, what happens if someone files copyright but nothing happens? And then there was a later clarification that they meant copyright registration. Dina.
Okay. Yep, I did type an answer in there. I don't know if I posted it, but if somebody files for a copyright registration and they never have to use it for an infringement action to demonstrate evidence of, when they began or when they first fixed the copyrighted work in a tangible medium, I think that's probably a win for the author in that case. Really, that's what the registration is there for more than anything, is really to demonstrate the date that you created and fixed the copyright in the tangible medium. Typically, we would use that evidence for, enforcement purposes. You can also, there's different indicia of the way that you mark your work as copyrighted if you want to, but registration is not required for your work to be protectable under copyright. It really sits there with really not a lot of back and forth between the Copyright Office and the author. It just sits there mostly as evidence for future infringement actions if needed. Hopefully that answers that question.
And whoever asked that question, please feel free to go back into the chat and follow on if you have additional questions on that. And then Dina, do you mind answering the question again orally about what would be the economic impact if the term of copyright protection is reduced?
Sure, I can definitely do that. So this is something that people debate for sure. And I guess the main, while there may be some benefits, there could be some economic benefits for sort of getting the copyrighted material into the public domain, free and clear of potential infringement issues. The US does subscribe to international treaties on IP, different tenets of IP law, including copyright law. So, a big one is the Berne Convention. And in the Berne Convention, there's a minimum term requirement to be a member of the convention, which basically is sort of trying to harmonize copyright law internationally. And that under the Berne Convention, the minimum term is author's life plus 50 years. And then there's also this sort of shorter term provision in there where a country isn't able to provide, shorter copyright term than the country in which the work was originally published. So it's suffice to say, harmonization of our laws with the rest of the world, especially in an area like copyright law, where we're dealing with, all manner of digital things, it's really important in terms of international economic influences, if you will. So that's probably the biggest factor to think about when you're thinking about messing at all with the copyright term, shortening or lengthening it.
Thank you, Dina. And just to clarify, I think I told people to go to the chat, but it's actually the Q&A. The next question we have, and I guess this one could be for, oh, it disappeared on me. There was a question on the logo intersection between trademark and copyright law. The way that trademark law and copyright law impact a logo, since the logo itself is also a work of art. Dina, sorry to call on you again. Do you mind also providing your answer orally?
Sure, I can definitely do that. And please, Marcia, weigh in here too if you have more to add on this one. Logos are definitely protectable under both copyright and trademark laws. And again, as long as the logo is original and creative and fixed in a tangible medium, it's protectable under copyright law. As soon as it's fixed in the tangible medium, no registration required for those logos. On the flip, in order to be protected under trademark law, the owner would need to file an application with the U.S. Patent and Trademark Office or the USPTO. And in order to do that, you need to demonstrate that you're using the mark in commerce, in interstate commerce, and also if you aren't using it yet, you have to file what's called an intent to use application, and that's time limited. So you do have to loop back and demonstrate that you're actually using the mark to sell something in commerce. And then you may go back and forth with an examiner at the trademark, a trademark examiner at the U.S. Patent and Trademark Office, and they weigh all kinds of different considerations, the distinctiveness of your mark, given the products or goods or services that you're using it on, as well as, other people's marks that could be confusing and similar. And these kinds of things are the things that they'll consider before they decide whether you get to have that trademark registered as your trademark under U.S. trademark law.
Thank you, Dina. Would one of the panelists be able to answer the question about whether patent, trademark, copyright lawsuits make up a large part of court cases, and what are most of these lawsuits on? I think maybe, okay, go ahead, Go ahead, Marcia.
Yeah, I was going to say absolutely. They do make up a significant portion of court cases, particularly in developed economies that really emphasize the importance of intellectual property rights in being an engine for that economic development. So these cases, they are often very high stakes litigation. They require substantial financial, investment on both parties. There's a whole industry in many industries, in fact, in providing, support for driving those litigations forward. So these cases tend to be around, patent infringement or copyright infringement, trademark infringement. You also have, the topic of trade secrets misappropriation that we didn't discuss in this presentation, but that's often the subject of many news articles out there, especially, in very high priority industries for the government, like semiconductors, for example, and so forth. You often see articles of, employees trying to, they leave their company and they try to leave with the trade secrets of the company to then sell it to the other company or, in different country and so forth. So those cases are very, very high profile and tend to be very complex. A lot of these cases involve expert testimony, technical evidence, and again, very high rate of legal fees. But I don't know the percentage of intellectual property cases compared to, say, other areas of law.
And I think the bulk of those cases are patent cases, correct?
That is correct. I would say so.
So in terms of interpretation of the patent law itself, it's not very common for cases to go all the way up to Supreme Court. For example, the Alice case that I mentioned happened like 10 years ago, and they're still interpreting, what the Supreme Court said as to what abstract ideas or what software inventions, what type of inventions or business methods are patentable, for example. So it's not common for the highest court to take up patent cases. So in terms of the in terms of economic kind of like impact, I think patents certainly have one of the largest impacts because they they include design patents and all kinds of ideas. And the whole innovation ecosystem depends on the patent system working. So you can imagine that to be a significant part of the overall litigation space.
Thank you, Kannan. So moving on to the next question. Can trademark protect a recipe and copyright protect the processes to make the product?
So trademarks and copyrights do not immediately protect recipes. So recipes can be either trade secrets, as I mentioned, that are kept very closely guarded, especially if they provide that owner of the recipe a competitive advantage over others. And in terms of processes, depending on the recipe, if it's a complicated recipe for, a formulation of a product, then that process could be actually patentable, right? But not copyrightable. So copyrightable are the works of authorships. Patents protect the innovative aspects of solutions to problems. So if there's a problem that needs to be solved in coming up with a more efficient process for executing the recipe, then absolutely, right? So you're talking about recipes in general, right? Not just recipes for cooking.
Thank you. There was a question that is not quite finished. So the person that wrote, can copyright protect one's P? If you could go back and rephrase your question, that would be helpful. I'm a little unsure what P refers to. And here's a patent question for you, Kannan. Are there specific regulations specified in the US code that describe what makes something non-obvious or not for a patent? or is it something that is interpreted by a judge on a case by case basis?
No, I mean, there are US statutes for that, like the 35 USC 103 concerns obviousness. So there is a set of requirements to like for a patent examiner to cite a case, and in case of a patent can be challenged on the same grounds under the same law. If we can show an invention is non-obvious of a combination of different, like, art, and that could be, patents that predate the current patent or application, or it could be publications and so on, and even products in the marketplace. So it's not, it is a case by case analysis depending on the current technology or product at stake, like the current patent or patent application at stake. But it is an application of well-established law in a way. It does not change a whole lot.
Okay, thank you. There was a question that was answered via chat on whether trademarks and copyrights can be renewed after expiration. So I'll just recap that trademark rights subsist or exist for as long as you are using the mark in commerce. So you're using it as part of your business. And some countries, or many countries around the world, do require owners to file evidence on the frequency, sometimes on an annual basis. For copyrights, once your term expires, your rights to the copyright also expire. I think, oh, here we go. One more question here. Is there anything in the natural world that cannot be patented or you cannot request intellectual property rights for? Sorry, Conan,
So I covered this, I covered this in my during my talk. So naturally occurring substances, things of the nature like the plants, unless they're engineered, or the process of engineering it into another substance, that process can be patented, but naturally occurring things cannot be patented. I think that's the question, right, Gail? Or
yes.
Was the question something else? Or yeah.
Okay. No, that's the right question.
Yeah, I think a bunch of things cannot be patented. Let me repeat that for you. Laws of nature, natural phenomena. So those are the two primary things. Laws of nature being like, if things happen in one way in nature all the time, then you cannot patent that because it is how things work. Now, an application of a law of nature for a particular use case can be patented.
Thank you, Conan. So that's all of the questions that we have today. I think we have a few additional slides that Shirley can go through. If any questions come up, please feel free to input them into the Q&A until we are done with this webinar.
Sounds great. Thank you so much, Gail, for moderating the Q&A, and thank you everyone for answering all these hot questions. And this was a really good taste of what the IP world is all about. And in case you're still interested and want to know more about IP, there are a lot of resources online that you can actually go and check out. You can go to the United States Intellectual Property Alliance. Their website has a section called IP Resources, which has a lot more content on there that you can browse through. You can also go to the Center for Intellectual Property and Intellectual Property Understanding and check out their resources section as well. I would also recommend for educators that are listening today to go to the Lemelson MIT program to check out invention education resources that discusses various aspects of IP that you can use in your classroom. And so that's a really good resource as well. You can also check out the Michelson Institute for Intellectual Property. They also have a resources section that you can take a look at. there are a lot of videos that are posted on the database, which are really nice and easy, well, nice to check out. For people who are preparing for the national debate topic, we actually have a collection of YouTube videos that you can also look at as well. These videos talk a bit about the impact on the policies that we have in the United States about surrounding IP. And if you or your students are interested in a career in IP and doing this for a living, be sure to check out our ADAPT website, Advancing Diversity Across Patent Teams at adapt.legal. We have two things of interest. One is for a section for students and professionals to check out what type of IP professions there are. You can click on for students and professional and get to the professional guide. There's also a mentorship program that you can sign up for in case you don't know anybody who's in IP or you're just generally interested in entering a career in IP. You would be connected with a mentor who can guide you through and navigate through a career in IP. All right, I'll stop sharing. Tracy?
Sorry, one
sorry.
second, Shirley.
Yeah.
Conan, I think somebody wanted you to repeat the last thing that you said when you answered the question on natural world, whether anything in the natural world could not be patented.
Laws of nature, formula, things that happen, like, the sun rises in the east, and for example, how particular, the force, the gravitational force, and any kind of like equations that you may think of that explains the nature around us cannot be patented, but the use of that or the application of that such laws of nature can be patented.
Thank you, Conan. And Stephanie, back to you. If you don't mind just providing a little bit more information on the upcoming events for those that missed the first part of this webinar.
Yes, so I mentioned at the very beginning that tonight's webinar, IP 101, is really a broad overview to intellectual property, and we will be making tonight's webinar accessible after this event as a recording, so you can come back to it. And then on October 24th, we will focus on hot topics regarding the United States IP laws and careers in intellectual property. So sign up for that one. And then the third one is November 20th, and the topic will be deep dives into arguments for and against strengthening the United States intellectual property protection. That's the actual debate topic. We'll be going really deep, and this will include individualized coaching. So we'll actually try to pair you up and get your specific questions, high school debaters, your specific questions that you need so that you can be better in your next set of debates. So we need the teams, though, to pre-register. Very important that you pre-register. So the link, we're putting it in the chat again in case you join late, or I guess it's not chat, it's Q&A, sorry about that. But we'll put it in again, please register. And I want to, once again, the last slide is to just thank the awesome team and our speakers tonight. We really appreciate the expertise that you've shared with all of us, and also the wonderful advice we've been given from our advisors with the Silicon Valley Urban Debate League, helping this incredible team be able to know what kinds of things might matter to high school debaters. So we really appreciate Kwojo Moore, Robert Burns helping us understand what you all might need. And to that point, these are for you, high school debaters. So if you have needs and you want to let us know way in advance so we make sure we meet your needs, please send us an email. Tell us exactly what would help you. That's the whole reason we're doing this. We are just so excited that you would be delving into this topic. And since we live it every day, we know how hard it is, and we want to be there for you. We're really proud of your work. So with that, I am going to.
Stephanie,
Oh,
sorry,
yeah.
we actually have 2 more Q&A questions that just came in.
Okay, wonderful, Gail. Thank you so much. You keep them coming.
Conan, there was a question to you on which patent case that you were referring to.
It's Alice versus CLS Bank. Alice is ALICE, is a landmark case for software business methods and that type of applications, which is very relevant in the new, and we are still fighting this, for example, for AI applications, and it's very relevant these days. And the USPTO, for example, puts out example guidelines and examples, patentable examples, and subject matter that may not be patent eligible. So it is still very specific to each technology and case, but what generally should be considered an abstract idea and how to deal with abstract idea was established in that Alice case. You can Google Alice versus CLS Bank.
Thank you, Conan. And I think the last question may actually be for you, Stephanie. The question is the registration for kids?
Yes, well, our intent here is to really meet the needs of the high school debate teams. But, the webinars themselves, everybody can benefit, and we want as many people as possible to be able to benefit from the webinars. But the November 20th, where we'll be pairing people up, we really want that to be that pairing to be for the teams, because we have a limited number of advisors we can recruit, and we want to make sure that we're supporting the debate teams. But as far as attending and benefiting from the information we share, we're happy to have anyone on.
And I think that actually gets us to the end of the Q&A.
Okay, great. Well, again, the planning team, you, Gail, Shirley, all the folks we were just showing on our screen. We couldn't have done this without you two. So thanks to everyone for the group effort. And if you know other high school debate teams that weren't here tonight, please spread the word.